As your Lordship said, I could have made 3 columns. Also, I could have made 4 columns. Why does the Lordship prefer that column to this column, to this column, to this column? Let there be 5 paragraphs, 3 paragraphs, 2 paragraphs. Why that is preferred and this is not preferred, this is preferred, this is not preferred. I can't make a table and give a Lordship. These are the various versions. The impugned order of the governor was passed in undue haste with a predetermined mind and exhibits a cherry picking. This word cherry picking is very important. I'll just show in a minute. But this is a case which demonstrates without doubt there is cherry picking. Without doubt. And very interesting. It shows cherry picking in the wrong and it shows cherry picking in the right. I'll just show that in a minute. Very interesting case. Where the present case was unduly and hastily fast-tracked, while several other applications for prior approval remained pending for long duration. My Lord knows those 6 examples I gave. One year, one example is 2 years. 2 years. 2 years. Interestingly, while your Lordship is hearing that matter...
Still pending?
No. While your Lordship is hearing the matter, perhaps somebody's arguments have had some effect. One of those 2-year applications has been decided on 8th of August. And that is the cherry picking I'm going to show in a minute. After your Lordships have heard most things just now. And it's very interesting. It's very instructive as what the governor could do, should not do, and did do. That is the complaint of which month in 21? 2021, which month? It's in 21. Decided in 24. Mine is taken up the same day and show cause is issued. Nobody is going to come and say this is Article 14 arbitrary written on the file. Your Lordship, read between the lines.
That was sanction or approval?
That was approval.
17A.
Your Lordship would not even find a 17A pending for 17 months. Here we are 3 years. Give me the date of that. I am instructed.
No, it can't be 17A, I guess.
It should not be. It's different from can't be. It is. It is.
17.
You sure?
Page 127. Do you want me to give it?
120. Give it. 127, we have the order. Let's be factually correct. Details. This is a supposed sting operation on camera for a person supposedly supplying eggs, etc.
In school, midday.
For midday meals of schools, recorded on candid camera, where the Honorable Governor takes 2.5 years to apply his mind, and after 2.5 years or 3 years, rejects it. In my case, for 20 years, not a single file dealt with by me, and he issues show cause on the same day. Well, this is not Article 14, it's shocking, is the word for it. Till when it came in, your Lordship knows those so many decisions, Charanjit and R.K. Dalmia, we had basically the discrimination facet of 14. Classification, doctrine and discrimination, but classification mainly. In Royappa, which came 30 years after 74, 30 years after independence. Justice Bhagwati, for the first time, brought in the seeds of arbitrariness. Then those 70s and 80s, the same Justice Bhagwati developed it beyond compare in all the Ramanna Shettis and all the cases. I hope I am clear.
Yes.
So you had a second facet of 14. Then the third facet came in Maneka, developed later, or procedural due process. We still kept the figment of the fig leaf of denying that we have no substantive due process in our constitution. Because the Lordship knows Venegal Rao had gone abroad.
Yes.
Frankfurter had said, do anything, but for God's sake, don't put this phrase, due process. So Article 21 had a due process clause, or the counterpart article. So when Venegal Rao met Frankfurter, who was a very restrained, limited judicial review man, he said the bugbear of American jurisprudence is this crazy phrase, due process. Don't use it, do anything else you like. So Venegal Rao came back and reported. So they put this phrase, except in accordance with law from the Japanese constitution. They dropped due process. So we like to say that we had no due process, but Maneka brought in procedural due process, clearly. So that was phase number 3. Then finally now, in a trinity of judgments authored by Justice Nariman, there is full-blooded substantive due process. Both Venegal Rao and Frankfurter must turn over in their grave. Because triple talaq, this adultery, then that Swiss ribbons, all of them recognize IBC under different. That substantive due process is a part. So your lordship can see the degree of unjustness to strike down. Now, I am saying that if your lordship were to apply even the old test of 14, now we have 4 facets of 14. This kind of conduct that you take 3 years minus 4 months for a 17A and then reject it for a candid camera. The complaint is there, Wallace. It's a recording of what is done about midday meals. And on the same day for a person who for 23 years has not signed a file, not made a recommendation, not been anywhere, you issue a show cause. Then, Wallace, you don't need Article 14 for that. You need common sense, is all that I'm saying. In relation, I have to put the point formulas. In relation to functions that are vested in the executive, the governor shall act at the aid and advice of the council with the chief minister at his head. The governor shall not exercise executive functions personally. 48 and 57 paras. Where the constitution provides that the governor shall act in his discretion, here the articles are correctly put, Wallace. Even in these matters, the governor shall act in harmony with his council of ministers. These are nuances which we tend to forget. It is not, this very interesting nuance. This Shamsher Singh, 74, is saying that even where he has a separate power, he must act in harmony with me in that. Look at the whole delicate balance. You can't say automatically I receive the cabinet decision because the chief minister is involved, I'll differ. Thus, there is a constitutional restriction on the discretion which is not to be exercised as a personal function or as a function conferred on him, eo nomine. In very limited scenarios, such as under 356 is a classic case, fellows, and 200, the governor may act in his own discretion even against the advice of his council. In such cases, the governor is to exercise his duty to the best of his judgment. That's para 55 and 56. Now, the most important, Justice Krishna Iyer. Now, why it is misrepresented, Justice Krishna Iyer is right. Not a word in the majority. He's concurring. Not a word in the majority dilutes or overrules or goes against him. Then why should Lordship not read Krishna Iyer? Justice Krishna Iyer just brush aside, he's a concurrence. But concurrence is not a dissent, fellows. Please don't read the concurrence as a dissent. You can point out that this concurrence is violated by this part of the majority. That I can understand. Not a word.
For himself in Bhagavati.
Ignore it because of the concurrence. And Justice Krishna Iyer spoke for himself, Justice Bhagavati. If the inner voice of the founding fathers may be any guide, para 113, it is proved beyond reasonable doubt that the president and for sure the governor enjoys nothing more and nothing less than the status of a constitutional head in a cabinet type government. A few exceptions and marginal reservations apart. Mark this word. A few exceptions and marginal reservations apart.
Yes.
Actually, the governor has more powers than the president.
Yes.
People tend to forget that. President is even more limited. Governor has little extra powers. For example, president has no 356 powers.
Yes.
Our Pakistan president has a 356, which he has liberally excised 2 or 3 times. He dismisses the national government with us. We decided against having that in the president. We had it only for the governor. Nobody can dismiss the central government here with us. Of course, there is some qualitative difference between the position of the president and governor. The former, under 74, has no discretionary powers. The latter too has none, save in tiny strips. Look at the approach. Tiny strips covered by, please forgive me for the typos, but it's 163, someone's coming at 1C3. And all the others are given. These discretionary powers exist only where expressly spelled out, and even these are not left to the sweet will of the governor, but are remote controlled by the union ministry. This is very important. The governor, when he acts independently, so-called, is independent of the state government. But the union government is answerable to parliament with a whole set of provisions. Lordship knows the 356 proclamation expires if parliament doesn't approve it within a certain time period. Again, a minimal area centering around reports to be dispatched may not, that's for 356, not 35C. Even where express conferment of power of functions is written into the article, such business has to be disposed of decisively by the ministry, answerable to the legislature, and through it vicariously to the people, thus vindicating our democracy instead of surrendering it to a single summit soul. These are the simplest language which Justice Krishna Iyer may have used. He's erring on the side of oversimplicity. But well, a single summit soul has a rhythmic alliteration, which exactly describes the reason to avoid the governor or the president. That single summit soul is the governor or the president, whose deification is incompatible with the basics of our political architecture. Lest national elections become but Dead Sea fruits, legislative organs become labels full of sound and fury, signifying nothing, and the Council of Ministers put in a quandary responsibility to the House of the People and submission to the personal decision of the head of state. A parliamentary-style republic like ours could not have conceptualized its self-liquidation by this process. On the contrary, democratic, etc. Well, sometimes I think that how times have changed. Well, as today, even if you have a person like Krishna Iyer, he could never go onto the bench. Because we are into narrow confines. You can't be in public life, you can't be in law, you can't be on the bench.
No, he was in public life.
Actively, a minister.
Yes.
Forget active life.
As a
minister,
minister for 3 years.
and then became a judge.
Then became a judge of the Kerala.
Which is why he never made it to the top, but he was a senior judge. But nobody could raise a finger. That is the spirit of the times. Nobody could even suggest this. And one of my most cherished memories is that when as a young student, I wrote an article in the Illustrated Weekly.
Oh, the then Illustrated
Weekly,
yes.
a very famous magazine.
Yes,
about election law. I had been in some elections seeing something. Elections, law and reality. So I was juxtaposing. But Justice Krishna Iyer retired by then in his 80s.
Yes.
Wrote a very nice note handwritten to me, saying, I read the article. He knew my father, so he took the trouble of writing a note to me personally. And he read the whole thing and he wrote something which overwhelming to have him. Then 152. Long arguments on the terminological niceties of the various provisions, divorced from the essentials of parliamentary perspective, will land us in Himalayan constitutional blunders. Similarly, expressions like is satisfied, opinion, as he thinks fit, if it appears to, have to be interpreted by superimposing the invisible but very real presence of the ministry over the head of state. Opinion of, in the view of, appears to be. We declare the law of this round. This is 154, which was brushed aside by saying this is only a concurrence. So I've quoted it. Please tell me which part of the majority dilutes or violates 154 or tell the Lordship it is the overbreadth. Unless you do that, you can't just brush it aside. Supreme Court, 7 judges. In that way, Bomai could be Bomai Lordship at 5 and 9 judges with 4 or 5 judgments. Most for all concurrences.
Yes, concurring.
Your Lordship doesn't brush aside just like that. Very Karnataka flavor, Bomai. The most important change in 356 has been that Mr. Hegde, by the time Bomai was delivered, he was the petitioner originally.
Yes, yes.
By the time Bomai was delivered, the government had changed 2-3 times.
Yes.
He never got the fruits of his victory. Subsequent to 2000, there are only 7, 8, 10 356s. Because your Lordship's judicial review was not only the same as Bomai, very swift. Very swift.
So many things.
No, your Lordship's judicial review was very swift. I've had the privilege of assisting the court in Uttarakhand, Karnataka,
yes,
Maharashtra. Your Lordship decided within a few weeks, this way or that way. So 356 did not become a very valuable tool to dismiss government because your Lordship said reinstall him back. In all these cases, Uttarakhand, Karnataka, have the elections or have a floor test and all that. Bomai took 3-4 years before the man lost several governments. So he got a Pyrrhic victory.
Yes, it was a Pyrrhic victory.
It was a Pyrrhic victory, although he established law forever. This is the crucial part. Before him to assess whether the government seemed to have lost the confidence, loss of confidence in Lordship, normally I would imagine
that was a case
has a lesser reviewability, normally. But it's a good, robust judicial review is what I'm talking about. This is robust and correct. We use the term opinion to mean satisfaction based on objective criteria as to whether he possessed relevant material and not to mean his subjective satisfaction of the governor. Once a government is democratically elected, that's the principle. A democratic government has a right to do wrong. And the right to set right that wrong is not in an unelected governor.